Good morning. My name is Seamus Hughes. I'm the Deputy Director of the Program on Extremism. On behalf of our director, myself, and the rest of my colleagues at the Program on Extremism at GW, I'd like to welcome you to what I hope to be a fruitful conversation about terrorism prosecutions in the United States. And so today we were fortunate to have the acting U.S. Attorney for the Eastern District of New York, Seth D DuCharme, who has served at DOJ for a number of years, almost a dozen years, in a variety of different positions. Before being acting U.S. Attorney, he was the chief of the criminal division, held a number of positions in transnational threats, cyber crimes, and general crimes. He also did a stint at Maine Justice last summer as the Principal Associate Deputy Attorney General for Attorney General Barr. I've known Seth for a number of years. We've worked together on a number of cases. And so the point of this conversation today is there's a lot of talk about terrorism prosecutions, but we wanted to pull back the curtain a little bit and to give viewers the sense of what it means to prosecute individuals in Article 3 courts. What is the nitty-gritty of that? How does this work on a day-to-day operation? And I can think of no one better than the Eastern District of New York to do so. Preparing for this talk, we looked through the recent cases, something north of 100 plus terrorism cases that office has prosecuted. By far one of the most active offices in the U.S. on this. And so I should note too, this is going to be a start of a conversation. So we're hosting Seth today, but in the coming weeks, we'll also be hosting a magistrate judge from the D.C. federal courts to talk about what it's like to be on the other side of determining guilt or innocence of defendants. And then we'll have a number of other talks in the coming weeks. So one, I want to thank Seth for coming here, and I hope that we can have an informal conversation a little bit. But I would be remiss if I didn't offer an attorney the opportunity to do opening remarks. I thought maybe you could set the stage a little bit about, where do you see terrorism prosecutions in this country going? How does your office play a role? And then also, when do you decide not to? And what are the off-ramps available to this? So Seth, the floor is yours.
Great. Thanks very much, Seamus. I was delighted to receive your invitation to participate in this conversation. I think looking at the RSVP list and recognizing a lot of these names, this is a community that I'm very happy to continue to be a part of. I think I'll just start by, giving the audience some sense of what informs my thinking about counterterrorism and the role of the department and our office in counterterrorism. And that goes back to, for me, it's 2008 is when I joined the office and quickly became interested in working for a section that was then known as violent crime and terrorism, or lumped together. And I had a few investigations assigned to me in early 2009, and working with what I really think is a jewel in the crown of the United States counterterrorism effort, which is the New York Joint Terrorism Task Force. Just a wonderful group of people to work with, 500 operational personnel with responsibility for a large portion of the world, and then New York, the city. So I was introduced to that group, and it was a great culture of forward-thinking and forward-leaning people dedicated to protecting the city, the nation, and the world, really. And so I had a few cases that hit in the sense that we had the ability to bring charges. One of them that was most, important to me was a case called Batim Kazoo, where we had one American overseas in the Balkans and another we'd identified back here in Brooklyn, and we had only partial visibility into a plot which was aimed at a NATO base in the Balkans, and trying to work with the co-conspirator who was here in Brooklyn to disrupt the plot overseas and work with those foreign partners. It was really my first experience in counterterrorism prosecution. It was hugely rewarding because we disrupted a threat, and we had a trial, and we litigated classified information, and I learned so much, frankly, from our cooperating witness at the time about what had caused him to travel from New York overseas and to pursue the call of jihad, and who had influenced him, and how he thought about it, how he pressure tested some of those ideas. So it was hugely educational for me and for our office. And around that time in the mid-2000s, we had a number of active cases relating to Al-Shabaab, Al-Qaeda in the Arabian Peninsula, IJU, and we were running on all cylinders. And so institutionally, we were just learning a lot about these groups and trying to apply that knowledge across cases and finding experts like yourself and others, getting some good sentences and getting some good results, and then establishing, I think, as you said, some credibility with Article 3 as a means for the incapacitation of terrorists, with some transparency for the public, about how we do it in the courtroom. So good results. So that informed my thinking to a large degree. And then I think I probably took our extraterritorial authorities, to perhaps the outer limits, in a case involving 3 ethnic Somalis who traveled from, the UK in one instance, and then 2 from Sweden in the other, to Somalia, and then were picked up in a Horn of Africa country and brought, to Brooklyn to be prosecuted, essentially for their participation in al-Shabaab and their efforts, to move on to another group. And that very international case caused us to have to conduct depositions in East Africa, and to really push, physically, and I think within the bounds of our legal authority, to the outer reaches of our jurisdiction, on the principle that, if you catch a terrorist in a foreign country moving from A to B, from my point of view at the time, if you have the opportunity to remove that person from the world stage because they've run afoul of a U.S. federal law and they pose a potential ongoing threat to America and the West, you should do it. Now, in that case, we got a far lower sentence than in the case involving, the Americans from Brooklyn who went, and that no regrets on the case, but in terms of an incapacitation and a use of resources, it raises interesting questions about how far should we extend this reach? What should our, what should essentially our intake criteria be? And, if we look at a policy level and big picture on the current stage, where should we be leaning in, and what returns will we get on that investment of time, energy, and effort? And that evolved substantially the way I looked at, what is an efficient use of our energy to protect, principally the American public, but then, our partners when we can from the threat of international terrorism. What are our options? And with ISIS, as you well know, Seamus, that was really a game changer for us. With the Al-Qaeda and Shabaab cases, we had typically a longer flash to bang arc. The things that I had learned from our Al-Qaeda cooperators about how they essentially went through a process of cultural assimilation into a jihadist group where they studied Arabic, they learned the nasheeds. They went through these libraries of Alaki and bin Laden. They really did their homework. ISIS really changed all that because they dumbed down, what it means to be an international terrorist. And so with a little bit of social media contact, they were incentivizing in great numbers a band of people in the United States and elsewhere to very quickly mobilize towards violence. And I was the chief of our national security section at the time when, here in New York and internationally in the areas of responsibility that we had in Africa, Europe, and elsewhere, just close to an overwhelming, I'll say, I don't want to be alarmist, but it was an awful lot of information coming in. And suddenly, the 500 people at the JTTF didn't seem like an abundance of resources. It seemed like, maybe barely enough to try to discern what's a real threat that deserves our resources and attention, and what's what I would call an expression of ideations of violence or violent intent with no real correlation to a likelihood of action on that. And I would liken that to, what most of us, I think, experienced in, maybe high school, where you ran into people who would express, taboo, or violent ideations. They'd have violent images or posters, or they would dress in a way that was, provocative, but never went on to commit any act of violence. And so what we were seeing were similar things in internet space, little fragmented pieces of an identity that were alarming, particularly in the affinity towards ISIS and a hyper-violent message. So what did we do with those people when there wasn't always a clear pathway to the development of a material support charge in the way we had historically? Very low tolerance, to let an act of violence be committed, here or elsewhere, against innocents. And so how are you going to disrupt this activity in a way that's responsible, where conventional tools, law enforcement tools, weren't really working? And the going dark problem, to be blunt, contributed to that. We would see, the sort of the classic scenario we were dealing with was we could have visibility into like-minded people coming together with an affinity towards, let's say, ISIS. And they would say something cryptic like, I really love what the brothers are doing over there. If you like that too, go to this other part of the internet, which is more private, and let's talk more about things we can do here. And then that's it. And then we wouldn't see what was happening in that private corner. And that was concerning, and we saw an awful lot of it. So we started to try to become proactive, and where we could identify who the speakers were and where they were, we'd simply go out and knock on their door and try to get some feedback from that individual and figure out, is this person really a terrorist? By which I mean, I think it's worth defining, by which I mean someone who is committed to using violence to affect some kind of political change. Murder, kidnapping, assassination, like that's what I think of a terrorist. Are you trying to change the political landscape by using, extreme violence, particularly against innocents? And we had a series of uncomfortable experiences where what we met on the other side of the door, Seamus, was really not what we'd anticipated, and it put us in a reactive mode. And I can just give you 3 very quick examples. We had one person who was expressing that they were aligned with ISIS and that they were, planning to do something. And we didn't have a real case, and conventional law enforcement tools had failed to provide greater visibility. So we knocked on his door and said, hey, we're a little concerned. You've expressed you're aligned with ISIS and you might do something. And he said, yeah, that's right. I'm just waiting for ISIS to direct me to do something. Well, that's not a federal crime. It's a conditional threat, and we couldn't prosecute him. Rightly so, I think. I don't think you should be prosecuted for saying I might do something if something else happens. It was hugely concerning and surprising to us that somebody would just own that message. We had another person who, as an interim step, we had probable cause to seize a laptop and search that laptop, and we thought that might give us greater visibility. So we went to execute a search warrant to recover a laptop, and the subject tackled the FBI agent who went into the house and tried to plunge a knife through his chest and broke the tip of the knife off when it hit a magazine. So, we got that wrong on the threat assessment. We knew it was somebody we needed to look at. And fortunately, the agent, survived and the defendant was prosecuted. But a big surprise. And then perhaps one of the most interesting cases that I worked on, individual we refer to as Mo. This was a guy we saw gone to Colombia, had a job, had a supportive family, considered him very sort of, low risk on what we could see publicly, but we saw connectivity, social media connectivity to ISIS, tried to do a scared straight, on Mo, hey, we know you're talking to ISIS. You should knock it off. This is serious business. And he said, oh, I would never. You've got it all wrong. And 3 weeks later, partly in response to our pressurizing the situation, he tweeted his way into Turkey and then across the border into ISIS-controlled Syria. The upside there is, 5 months later, he remembered the names of the agents who'd gone to meet him and was able to get a message out of Syria and saying, hey, on second thought, you guys were right. Maybe I shouldn't be here. But just those 3 examples, Seamus, really made us, rethink what does it mean to do a terrorism investigation? What tools do you need? What conventional things, may not work? And that's what led to our initially a project to develop a disruption and early engagement, project. And then that became a national program, which was endorsed by the department, all FBI field offices. And recently there were some grants issued by Department of Homeland Security, I think in New York. Deep received about $750,000, which is, I think, throwing money after a good effort. And the department of justice is about to release, grants to recipients for working in, I think what's familiar to all of us on this call, that kind of middle space where you see indicia of somebody mobilizing towards violence, but they haven't necessarily committed an act that would normally, from our point of view as prosecutors, justly lead to a federal terrorism prosecution with a public safety concern that they could mobilize so quickly. So what do? For us, the secret sauce was having really qualified threat assessment professionals who we could talk to help us understand the data we were seeing, and recognizing it's very hard to predict, future human behavior. And then having a network that was beyond a prosecutor's office or what the FBI would or should normally be doing to mitigate some of the aggravating factors that could influence an individual to continue to have, a path towards engaging in political violence. And that network was, NGOs, mental health professionals, service providers, employers with a tolerance for risk, who wanted to come together and say, hey, we want to be part of this solution. And all of us agree that, bringing the heaviest hammer of the federal government down upon an individual doesn't always, lead to greater public safety, particularly if if it results in a short incapacitation. These are tricky problems. That model of looking at some of these cases, I think, has proven adaptable to other types, of threat streams or indicia of people mobilizing to violence, whether that's a potential school shooter, who might be looking into what I think the AG referred to as sort of a witch's brew of, bad ideas, essentially, to incentivize violent behavior. So from the potential school shooter to, the domestic, terrorist, not hearing a call, from a foreign land, but hearing a call from inside the United States. And how do we mitigate that? I'll say, look, I'm a prosecutor first. I think I had credibility to do some of this unconventional stuff because nobody questioned that when the evidence would justify the heavy hit, we would bring it. Our office, and I personally have brought very aggressive, appropriately so, I think, charges when the evidence supported it, and the punishment, from my point of view, potential punishment, at least, was just. But there is undeniably a band of people who I think are, can be steered to some degree through a collection of, incentives and potential consequences. And so that's what we tried to do with deep, either non-prosecution, prosecution in a way that left open the possibility of escalation or de-escalation, for the government, and then trying to build that network and community engagement in a responsible way, not so that we can abandon our public safety responsibility. That will always lay with us, but to not ignore all the talented people who are out there who have an appetite for risk, who may have subject matter expertise, who can use, their skills to mitigate some of those threats. So, that's a view of sort of, I guess, 10,000 feet of some of the things that have informed my thinking. When I was in Washington for about a year and a half, working with the Attorney General and then in the DAG's office, that gave me the higher level policy role with the department to think about how we're going to do counterterrorism, how we're going to deal with domestic threats. And so, while it got me away from the courtroom in the specific cases, unfortunately, it did give me, greater access to the way these decisions are made at a policy level. And just coming full circle about what is the metric right now for international terrorism, I think, my friend John Demers, in one of his recent statements, sent a very clear message about how the department is looking at international terrorism, which is, if you have American, I think he said something along the lines of, if you have American blood in your veins or American blood on your hands, then we're coming after you wherever you are. And John also called upon our other international partners, to do their fair share in dealing with their own citizens in a similar way. So I think there will always be, terrorism cases will always be looked at on a case-by-case basis. Fortunately, they remain aberrant in terms of human behavior. It is still an aberrant thing for one human to take up arms against innocents for for political means. And so fortunately that will give us, I think, the benefit of being able to not have to apply very blunt policies in counterterrorism. I think we have those, we have the resources and we have the visibility. And so I'm heartened by that. It's just the consequences when we mess up are so disproportionately high to other practice areas. It really, an act of terrorism, can shake the world. So we're doing the best we can back here in New York. I've been delighted to reconnect with my friends at the JTTF and maintain the relationships, that we have in DC, and just try to do the best we can on behalf of the American people. So I hope that meets your expectations of sort of, my background and an overview, and then really look forward to having a conversation with you and some of the other attendees today about what might be of interest.
Thanks, and thank you very much for the overview. Listen, I would be remiss if I didn't take the opportunity to cross-examine a U.S. attorney, and so I wanted to touch on a few of the points you brought up. One thing I think is most interesting is you talk about the tempo in the height of ISIS, like 2015, 16 timeframe.
Yeah.
Having 500 JTTF agents, but feeling most days it's not enough. Where are we now on this? Are you still kind of treading water? Has things changed? Has the threat picture changed? Are you looking at more kind of domestic terrorism or white supremacists or Nazi groups? Is ISIS still kind of playing a role in the prosecutions? Where do things stand for your office?
Yeah, so we have some great ISIS cases of relatively recent vintage, in the pipeline up here. Trials have slowed down due to COVID. So our ISIS cases are still here. We're obviously continuing to work very closely with the JTTF to mitigate whatever the either classic Al-Qaeda threat. We know that Al-Qaeda takes its time, so you can't really ever drop your guard with Al-Qaeda and their affiliates. I would say the tempo, though, of ISIS has subsided considerably when I compare the experience of, say, 2015, 2016 to what we're dealing with now. A little bit anecdotal, but it was kind of a running joke in 2015, 2016. If it's a Friday night and 10 o'clock, where can you be found? Well, you can be found in the JTTF, because for whatever reason, that's when these little spin-ups, would happen. And that was taxing. That was really taxing on people, and it felt like it was right here. I mean, there were bombs going off in New York City. The resilience of the city was impressive to me. I mean, it was very distressing to me when we had like the West Side Highway and Port Authority and the Chelsea bomber. I mean, it was a dynamic environment there. And for those of us who have committed most of our professional lives to counterterrorism, that was really distressing to see those things happening. Essentially, you could see those, crime scenes from the top of the building. It's right here. It's not like that now. Not even close. So, we're never going to get complacent about the threats of, posed by foreign terrorist organizations. But it's subsided considerably, over the last couple of years. Current threat, that's always the question, right? You can't be constantly fighting last year's battles and backslapping for the successes that we had in historical AQ cases, 10 years ago, or the methodologies that we used in ISIS, which I think ultimately proved effective to triage some of these bad actors, solve what we could with criminal prosecution and solve other problems in other means available to the United States government that work overseas and are not available here, through military type action or other action. So what do I worry about? I mean, my ultimate responsibility is, to protect the Eastern District of New York, our community here, Long Island, Brooklyn, Staten Island, Queens. And then, as you know, the U.S. Attorney's offices, have a long reach because the courts have been generous to us on our venue and jurisdiction analysis. So, where are we looking? I'm looking at the types of activity that threaten, the integrity of our national institutions. So we're focused on election security. We've been running very aggressive tabletop exercises to protect as best we can the integrity of our elections and to give people confidence in the elections and also their physical safety in participating in First Amendment activity. whether that's a march across the Brooklyn Bridge or their expressions, on social media, that those things will be, that our role is to protect our citizens while they engage in First Amendment activity, while at the same time, sort of peeking through keyholes to try to see who would avail themselves of what has become a relatively permissive environment, physically and on social media, who would take advantage of that permissive environment to do bad things. I mean, we've had spikes in just gun violence in the Eastern District of New York that I don't attribute to any sort of sophisticated domestic terrorism plot, but an unfortunate consequence of that is it chills people's desire to just go out in public and express themselves and feel safe and feel free. So, we've shifted some resources essentially to help support the work of the DA's offices by using federal tools to up the tempo and the capacity to try to just counter violent gun crime. We're also, I think it should come as no surprise, very attuned to any conspiratorial activity or other inchoate offenses that are aimed towards violence to affect political change. I mean, I won't comment on other ongoing cases, but there have been some in the press recently considerably alarming, I would imagine, to the American public about these little plots, to target elected officials. I mean, that's, I think it's fair to say the kind of thing that we would agree would be domestic terrorism. So we're very much I'm sorry.
Tools when it comes to the domestic terrorism apparatus. So guy goes to LaGuardia and he's going to Turkey to go join ISIS. That's material support, right?
Right.
It takes a little bit different. It's a different tactic when it comes to domestic extremism. Does the law allow you the freedom that you would want in order to look at these cases, or do you have to be creative?
Well, I think it provides a sufficient suite of options, and I think we should be wary. I think we have been wary about expanding, federal statutes or tools based on, what you said, do you have the tools you want? Not always, but I shouldn't necessarily have all the tools I want. I should have, frankly, from my point of view, just enough tools to satisfy the need, right? I mean, we're a country where our Bill of Rights and our laws are essentially designed to limit the reach of the federal government in an appropriate way. And I don't worry on a day-to-day basis that we don't have enough federal tools, to protect the public. Do we have to be creative? I don't even think it's really, creative, because no one should ever be surprised by a prosecution theory, whether it's the defendant, the public, the jury, the judge. I mean, we have to strictly abide by rule of law. And while there's a lot of room for prosecutorial discretion there, and I think it can, frankly, sometimes benefit the defendants, just going back to that notion of deep. I mean, sometimes we used federal charges to disrupt activity because the person happened to be guilty of, let's say it was, ATM skimming or something. That allowed us to disrupt. I don't think that was an abuse of that federal statute, but it wasn't a federal statute that was necessarily designed to be part of a counterterrorism effort. And I think here, if people are engaged in serious criminal activity such that it implicates a national interest, I've not encountered a situation, where I flip through Title 18 of the United States Code and can't find a statute that will help address what the offense conduct is. That day could come, and if it does, then hopefully Congress will act responsibly. But I don't spend a lot of time wishing, for example, that I had all the tools available to investigate domestic terrorism that we have to investigate international terrorism. I think there are important distinctions, and I think the First Amendment rights of our citizens to engage in activity here domestically, I mean, they are, just as a matter of law, differently situated, from someone building a caliphate, in Syria, rightly so. How we use the conventional tools by which I mean undercovers, CHSs, search warrants, Title IIIs. Those existing tools, I think, need to be used responsibly, and in my experience, at least, are being used responsibly. Now, recognizing that when you introduce a government actor into one of these scenarios, just as we learned in counterterrorism, you're gonna inevitably influence, what's happening, and we cannot influence the sanctity of our political process. I mean, politics has become a pejorative, unfortunately, but the political process is, an essential part of our country's history, and it's what we rely on when it works well. So when you talk about domestic terrorism, certainly the expression of an idea that's hostile to a political party is well within, what we contemplate as appropriate First Amendment activity. We need to be very, very attuned to where it crosses into what I think you and I would agree is terrorism, and that's the use of violence to affect political change. And so, I think the federal statutes typically, when you talk about that actual type of conduct, whether it's a federal person or federal property or the use of an instrumentality that implicates interstate commerce, the courts have been pretty generous to us about interstate commerce nexus. And then the fact that our task forces that were built up in our counterterrorism effort, which include here in New York, of course, the New York City Police Department and state and local actors, which have other statutes and resources which can disrupt and prosecute, if appropriate, some of the types of activity. I think that's been a good thing to come out of our counterterrorism efforts. We now know how to work together much more effectively with state and local partners and mitigate, I think, spillover prejudice to, it sounds absurd to say the vast majority. Terrorists make up, you can count them ideally, in your AOR, even a busy one like this, you can typically count them on, one or two hands. So we're not going to come up with policies or set precedents or ask for tools that would disproportionately, from my point of view, prejudice in some way, or even potentially prejudice, the great majority of people who are law-abiding citizens engaged in protected activity.
Right. It's a good point. I wanted to touch on two things that I think are related. You talked a little bit about ISIS and this kind of flash to bang being a shorter period.
Yeah.
And you also talked a little bit about your office's work on election security and making sure folks can vote without fear of violence. Does the upcoming kind of, do you see this as a touch point, and do you see the need, that flash to bang possibly limiting when it comes to domestic extremists in the next couple weeks? Like, are you going to have to make prosecutorial decisions soon because of things that are coming up, or is it a case-by-case basis?
Well, it's easy to adopt the latter there. I mean, it is truly a case-by-case basis. I think in terms of election security, a lot of what we've been doing is, frankly, not related to a specific fact pattern that gives me concern, particularly in our geographic area of responsibility, but rather coming together in a bigger kind of a task force model with all of the different stakeholders in this effort to understand, who should have ownership over what types of activity, so that we can issue spot now, we can communicate more effectively, we can work more effectively in a way that's truly complementary. I think there's the danger of overreacting is as significant here as the danger of underacting. I mean, the goal is to protect the integrity of the process and to give confidence to the American people that there's been no material interference. So part of that is, if we knew, and this is a pure hypothetical, but if we knew about some inchoate offense conduct, by which I mean attempt or conspiracies right now that could materially affect the integrity of our electoral process, well then yes, we would have to find a way to very surgically and transparently, frankly, deal with that element. And I can give you an example from the past. I mean, maybe this is the most blunt example, but it's a serious one. In the physical environment, our office has historically prosecuted people for interfering with elections, by attacking people, essentially. That use of force or threatened use of force. If you try to go vote for this person, I'm going to club you. If we saw a plot moving along those lines, then we would certainly disrupt it. We would charge those people, and we would probably issue a press release saying, that they were threatening violence against people for participating in the process. And we've gotten good sentences historically on that kind of conduct because it's so egregious. But it's also something that you can compartmentalize a bit, because it's these three people acting in both an aberrant and abhorrent way, and it runs afoul of these very reasonable federal laws. I think the ones that are trickier for us is when we have this kind of soft cyber influence stuff, whether it's a foreign actor. It's news to no one on this call that there are foreign actors who enjoy very much the chaos that they can cause in our country through whatever means. You have sophisticated foreign actors or domestic actors kind of working on the fringes of what we would consider to be acceptable, puffery within our political process. We have a high tolerance for puffery. We certainly don't prosecute, that. And so where would be the line crossing point from a federal criminal prosecution standpoint? What are we looking at? When could we do it? And if we do it, will we leave the American public, essentially better than we found them, or will we have contributed, to some confusion here? And that's certainly in the exercise of prosecutorial discretion, that's something you can consider. So that hypo would be fraudulent information disseminated on the internet with maybe a financial component. You should send me money because these facts are true, and together we can do this thing that touches on politics. That's pretty close to puffery. It could technically run afoul of the wire fraud statutes. And those are the kinds of things where I think, we're going to think very carefully before we insert federal law enforcement into that process. So that's what the tabletops really have been doing. Let's look at all these different scenarios. Let's talk to all the stakeholders, and let's get ahead of it. And we're standing up command posts as we would for any other type of, potential spark point, for here in the city or nationally. I'll tell you, I'm having lived through a lot of these cycles for other types of threats. I think we are giving it the appropriate amount of seriousness. I haven't seen alarmism, frankly. I'm not, I don't want to jinx myself. I'm not especially worried about what's gonna happen here in New York or even nationally. But we're certainly being vigilant, and we're certainly spending a lot of time to prepare, and we're trying to think about these things ahead of time.
Thank you. I want to move away from puffery a little bit and talk about, you mentioned one of the three cases you mentioned was the gentleman who knocked on the door to get his laptop, and he unfortunately stabbed a law enforcement officer. That cell of 5 folks was communicating with a known ISIS facilitator, Junaid Hussain, and who had communicated kind of a number of encouraging directions. When that happens, when you see kind of the homegrown, the American cases reaching out to the upper echelons of ISIS's propaganda and cyber wings, how does that change the dynamic for you? Do those cases rise to the very, very top at that point? Is it a different animal? Do you let it run for a little bit because, the intel's a little bit better?
Well, I think, there's always competing concerns. We try to get, the prosecutors and the agents, aligned in what the actual tempo for an arrest or takedown should be. And I think we've done a good job of doing that. But of course, the competing interest is, if you're strictly looking at it from a litigator's point of view, well, the longer this goes, potentially the stronger my evidence will be, because we'll have, more to tell, more clarity, more evidence. Whereas, historically in my conversations, with the FBI, they've said, what are you, nuts? the longer we let this go, the greater chance that there's some, harm comes to us or the public. And so striking that balance of when can you responsibly take it down? Responsibly, I mean to protect the public, but also to have a case that really meets the expectations of the court and the public and ultimately the jury if you go to trial. I mean, is this a terrorism case or was this, a disruption? And you talked about the probative value, of communications between a person in America and say someone in ISIS in the caliphate. Yeah, it's a significant aggravator. It's also substantially helpful if you're trying to build a material support case because now you have communication between the foreign terrorist organization and the individual, which suggests that there is some direction and control by the foreign terrorist organization over the putative defendant here in the United States. If you don't have that communication, then we're back in that world of, this could just be a person, surfing the internet in curiosity and expressing taboo ideas to their friends and exploring, this witch's brew of bad ideas. And they're really no more a member of ISIS, than they are of any other particular group. What they are is an individual struggling, to see how they relate to some of these ideas. So to answer your question directly, I mean, yes, when an individual in the United States is in communication, it's an aggravating factor. And how far along we let it go will depend on our assessment of the risk to public safety and our ability to serve a just end in the court system through through a federal charge. Are we there yet or are we not?
Let's continue on kind of the ISIS world because that's what I know best, right? So, you talked a little bit about Mo, this gentleman from the Northeast who traveled to Syria and spent a few months there. In that case, he came back and kind of admitted his guilt and moved on and faced prosecution. But can you walk the viewers through what it looks like to build a case in Syria and Iraq, or you mentioned that the case of the gentleman in Al-Shabaab. How many resources are involved in that? Do you get to a point where you throw up your hands at some point and say, we don't have what we want, and it's not worth the effort on this? How do you bring enough to get it to Article 3?
Yeah, well, we certainly, we do know how to do it. I mean, we know how to bring these charges. The material support statutes are generous to the government. I mean, I don't know how else to put it. They're generous. They're not especially challenging cases to make as a matter of law if you have, for example, in a conspiracy, an agreement, a meeting of the minds to offer yourself, or others in support of the group, or an attempt, a substantial step towards the completion of, let's say, joining the group. You referred to the airport, showing up at JFK with your bags packed, on your way to a transit country gets you most of the way there. So the cases, in some ways, to meet the elements of material support is not necessarily the challenge. In the international cases, of course, it will be, is the evidence available in a form that can be introduced at trial in a way that won't compromise other national security equities? So the Classified Information Procedures Act, as you well know, the more we know, frankly, about a subject, sometimes the more time we'll have to spend in a skiff leaving things on the cutting room floor, because the only thing that the government is required to produce would be information that's helpful to the defendant. So if you have a really righteous target, there may be a little bit of analysis or speculation that could be mitigating that will turn over in some form. But the vast majority of that work is just cutting parts of the case away, even though they're probative and aggravating factors. So that's a fair amount of work, but we know how to do that now. I would say the biggest challenge in the extraterritorial cases, where the activity has taken primarily, if not exclusively, overseas, would be the availability of those foreign witnesses at the time you need them. And those have been the kind of hold my breath moments, for me when we've indicted a case, but it's not approaching, it's time for trial maybe 2 years later, and you're relying on material witnesses, who live in, let's say, the UK, Germany, but it could also be, the Horn of Africa or the Balkans. And if you're relying on those witnesses, as we often do, how much comfort, can you have that that they're going to be there for you, and that you'll be able to, without as much leverage as we have domestically, by which I mean I can just issue a subpoena and throw somebody in the grand jury here. I can't necessarily do that in the Horn of Africa. So those cases, and we've done a number of what are known as Rule 15 depositions, where you can bring defense attorneys overseas, take the testimony of foreign witnesses, and they're subject to cross-examination. We've done that a lot, so we know it can be done, but it always introduces an element of unpredictability into the process.
And how do you guys decide whether it's you or SDNY or EDVA? What's the inside baseball kind of deal on who brings the cases?
Yeah, it's a great question. It's one my wife continues to ask me, when we issue a press release, how did you guys get this? In New York is different, frankly, from the way the rest of the country is set up with the U.S. Attorney's offices and the availability of the JTTF, and that's where I've practiced mostly. So I can certainly give you the inside baseball on that, and I think it's a process that's really served the interests of the American people in New York in particular, and that you have two U.S. Attorney's offices a mile apart, where we've been able to recruit a lot of smart lawyers, and many of those smart lawyers are drawn to counterterrorism and national security, and they feel really connected to it, so they want to work hard, and we both work with the New York Joint Terrorism Task Force, which, as I said, 50 agencies, 500 operators, and the way the FBI has kind of carved up the world, the New York JTTF has responsibility for a good portion of international terrorism around the world, and has broken, down into different squads, areas of responsibility. So, I always kind of chuckle when somebody says, "Oh, how come, you guys were given that case, or you guys got that case?" Like any other practice, it's the work of the investigators that builds it, and whether what's happening locally in New York, because it's a bullseye for our adversaries, unfortunately, or what's happening internationally, and the fact that the Second Circuit, courts have given us a long reach, the statutes have a long reach, the JTTF has a long reach, we have a big travel budget, and forward-leaning, young guns who want to go chase these cases down. That's frankly why a lot of cases have come to New York, and then the more you do of them, as you pointed out, if you have a history of success, then that brings a certain level of comfort. And I've spent a lot of time, I think, for something like counterterrorism, and I'll say, to my friends in the Southern District of New York, some of the best relationships I formed were with those prosecutors in the Southern District of New York who shared that passion for counterterrorism. We really did put all other interests aside there. I really saw that work beautifully. And then you do a lot of those cases, you have an expertise, and then if there's a high-risk case and the department is considering, where to support a case, because you're right, EDVA, DC, LA, there's lots of offices and lots of smart lawyers. A case could be brought. So if you got to a dispute, let's say, well, Southern wants to do it, we want to do it, EDVA wants to do it, all these other cases, then you have to sort of put your best effort forward, to the department at a high level, and you say, look, we think we're the right ones to do this, and look at our history of success. And somebody else might say, this can't all be about 3 offices or 4 offices. It's not in the greater national interest, so you got to give us our shot. And I really support both approaches, and did, frankly, when I had a role in DC in some of these mediations, for lack of a better word. I think we do want to keep institutional knowledge and incentivize, the great prosecutors we have in the offices that have done these traditionally. But we don't want to rely on compartmentalizing subject matter expertise, in a few offices, when the nature of the terrorist threat, it's really not about these geographic boundaries or districts anymore, as you know. So we should not compartmentalize expertise in New York, when the people of, Minnesota, Ohio, and Minnesota is experts in their own right, but these other places need to have the expertise too. The DEEP conference was a lot about that. It was, we're not going to be greedy, with our secret playbook. We're going to give it to our partners, and then, whoever can make the best case or make the best argument will prevail, and that's the competitive nature of how we do things. But I think it's worked out fine, and I think it's served the American people well.
And you mentioned, the need for expertise, and you talked about DEEP. And so I was hoping maybe we could wrap up our talk a little bit about where you see DEEP going nationally. So for our viewers, DEEP is a program that was, piloted in your district. You worked very closely on this idea of some level of prosecutorial discretion when you're dealing with full field terrorism investigations and off ramps for individuals and also individuals that are in jail getting out. And so that may work in the Eastern District of New York, frankly, because I think you talked about this idea of credibility. No one's going to call EDNY soft on terror. But how do you roll this out nationwide in 94 different U.S. attorneys' offices who don't have 500 terrorism cases ready to go at a moment's notice, and they just have this kind of one? How do you convince them that material support isn't the best route on this, and you may want to try a different animal?
Yeah, so I've been encouraged, over the last year since we had the conference. The grants, some of the grants went out, so that's always, we did it with no money. So I was only sympathetic to a point when people said, oh, I really want to do what you're doing, but we don't have the money. And I said, well, neither did we. We just had to do it. What I've seen is if you have a case or cases like this in your area, then this makes all the sense in the world to you, because you're dealing with an imminent problem. These subjects, who we investigate and investigate and investigate, but never get comfortable with, like that's happening everywhere. Whether it's ISIS or a potential school shooter or something else, those are out there. But when I sort of reach out to do a national data poll and I say, hey, is this really taking root everywhere? No, of course not. It's taking root especially in the places where people can see the problem right in front of them. I think it helps a lot that we've, you give something a name and you issue some memos and you throw out some money, and hopefully that sticks in the institutional fabric, of your organization. And I do believe that DEEP will stick. I think it's something that, look, even here, if we get to a point where we're not dealing with these cases, it will go dormant. Frankly, but the book is there on the shelf.
Do you see it as expanding past, traditional terrorism, extremism cases and more towards, I look
at it already is
school shootings and things like that.
Yeah, because, it's the ambiguity in those ISIS cases that are what caused us to need to bring in both out, frankly, very experienced psychiatrists and psychologists, who'd done threat assessment, typically in the employment space for a long time. That was their bread and butter. A company was going to fire somebody because they had been saying scary things at the water cooler. And there's a whole, network of people out there, some good, some not so good, who do that. That's their day job. So having those folks available to work with us, either in decisions about bringing a charge or how to resolve a charge, I think is extremely helpful. The ambiguity is always going to be there because it's as best we can draw inferences from what people say and how they express themselves. It doesn't always mean it's a federal crime, and it doesn't always mean it's a reliable indicator of the need for incapacitation. And so, whether that's a potential school shooter or violent anarchist or, whatever the concern of the day happens to be, I think there's going to be a place for supplementing what we do as prosecutors and law enforcement investigators with other information, other resources. I know the judges want it because they keep telling me that. The judges want to impose sentences that are fashioned, to both provide just punishment, but also they just make sense. We've had days and days of hearings. I mean, you testified in one where judges are like, you gotta help me understand this. Even if we get to that point, you've got to help me understand this. Even as early as a bail decision, is this somebody I can let out or keep in? The judges want this information, and we really want to exercise our discretion responsibly. We want to get it right, and so I think there will be a place for DEEP, and I think it's one of those rare places, Seamus, where there's a true alignment of interest in the public safety space between the defense bar, the court, probation, some of the NGOs. If someone engages in an act of political violence, it's lose, lose, lose just across the board. Nobody wants to see that happen. So I do. I'm hopeful that it will stick and that it will be available and that it will be malleable enough to adjust to whatever the threat landscape is of tomorrow. And I've seen some encouraging signs.
Well, great. Thank you. I should note we're up against our time, so I wanted to first, on behalf of the program, thank you for your time today. I know you're very busy, and we took it in a million different directions, and my cross-examination probably was a little bit softer than you would get from the FD, but not bad, right? So, one, I wanted to thank you for pulling back the curtain a little bit when it comes to terrorism prosecutions, and I hope this is just an opening conversation that we have at the program about how Article 3 courts can play a role in dealing with extremism in America. I should also, again, note that in the coming weeks we'll be announcing a number of other events related to this topic, including magistrate judges and defense attorneys and things like that.
No, it's my pleasure.
Program, I wanted to say thank you very much. So. Great. And like typical Zoom fashion, we now have technical problems. So I think I can speak on Seth's behalf and say thank everyone for joining us, and be sure to note that our session will be streamed on and uploaded on YouTube channel for others to look at. Thank you very much.
My pleasure.